Welcome to a bonus episode of This Week in Family Law. I'm Jenna Downey, and my very special guest today is the Honourable Garry Watts AM. How are you, Garry?
I'm chipper. You look like your normal cheerful self.
Thank you, Garry. And I'm very pleased to have you here for this bonus episode. It is a privilege to have you here and to be speaking to you.
Thanks.
And this episode is one of two special episodes of the series, and we will be talking about some cases that have had airtime recently and their Div 1 and full court decisions. Today we'll be talking about pleadings, Harman obligations, restraining lawyers and cryptocurrency as well. We'll provide viewers with a list of the cases in the show notes. Garry, let's first talk about pleadings in the FCFCOA. My understanding is that before I was even born, pleadings were used all the time in court.
Yes, there was a period in the family court's history where the court thought the best way to identify issues that need to be determined between the parties were to have them do formal pleadings, such as you would do in a common law negligence claim. And we had that for quite a while. So you would plead, for example, in a property case that somebody had made an indirect non-financial contribution, and then you would particularise what those contributions were, like you would give particulars in a statement of claim for negligence. That idea was never going to work in a discretionary jurisdiction, and after a while the court recognised that and abandoned it as a very bad idea, and it's never been revisited. So we've never after that had a case where in all cases you have to plead your case.
But pleadings, have still played a part in proceedings, haven't they?
Yes, in certain cases where they're ordered. And those types of cases are usually cases that involve third parties, the application of state law, the application of the corporations law. Those types of cases attract a consideration of making an order for pleadings.
So the full court has recently made some comments about pleadings in Fing and Ma. Can you tell us about the facts of that case?
Yes, in Fing and Ma, the husband sought a declaration that his daughter and companies owned and controlled by his daughter held particular property that they legally owned beneficially for him by way of both a resulting trust and a constructive trust. And what happened in that case was Justice Chanel found that in relation to the resulting trust, the money that had been used to acquire the properties had not been sourced back to the husband. The husband had not, in fact, proved that he'd provided the funds for the acquisition of those properties. And he also, on the facts of the case, held that there was no constructive trust. But the full court went on and said some things about pleadings.
From my understanding of the case, the full court took the opportunity to make a strong statement about the role and the effect of pleadings in cases where they are ordered.
Yes. What they actually said was that where pleadings are ordered, they should not be treated more laxly than in other courts. They are binding on a party who has been ordered to plead their case or that part of their case. They define issues and the admissibility of evidence, particularly on relevance in relation to those issues, and can only be altered with leave or by amendments to the pleading.
And if you had to seek leave to amend a pleading, what are some of the considerations that would be taken into account by the court?
The main ones that the full court emphasised were prejudice to the respondent, whether or not any prejudice could be accommodated in some way, and the need to finalise the litigation. So the later you leave an application to amend a pleading, the more difficult it is going to be to succeed in that application to be given leave to do so. And if you don't get leave, you're going to be stuck with your pleading that you'd wanted to amend, and you're going to be confined by it.
And what would you say to lawyers who predominantly practice in family law and might not be confident with pleadings if they want to rely in part of their case on, say, corporation law or state law? What tip could you provide them?
Well, the obvious thing to do is source a barrister who does that type of work and get them to settle the pleading for you. And in that way, you know that you've got a robust pleading that's been done properly by somebody who does it as part of their ordinary work.
And although some lawyers might think that pleadings are uncomfortable, is there an advantage to using pleadings?
I think there's a couple of advantages in doing a pleading in these types of complex cases where there's a complex claim being run that's an application of state law, for example. The first one is to stress test the viability of the claim you are making, and the second is to provide some type of framework and structure for the evidence that you then marshal to support the claim that is made in the pleading.
The next topic we will discuss is the Harman obligation. Gary, can I first ask you, what is the Harman obligation?
Well, I think the first thing to say is the Harman obligation got its name from an English case, which has been subsequently affirmed by the High Court in a case called Hearne and Street. So it's sometimes called the Hearne and Street obligation in Australia, but usually the Harman obligation. And the obligation arises when you receive any piece of information, any document during a family law case. You are taken to have given implied undertaking to the court not to use that information or document you have received for any other purpose than for the family law case itself. And if you want to be relieved from that implied obligation, you need to make an application to the court to do so. So that's basically what the Harman obligation is.
And there was a recent court decision of Kuang and Kuang which discussed the Harman obligation. Can you tell us about the facts of that case?
Yes, in that case, the husband had been charged with a serious criminal offence, and he went to the FCFCOA and sought leave to be relieved from the Harman obligation in relation to a particular report that had been prepared for the purposes of the family law proceedings. And the trial judge who was hearing that application refused it, saying that the husband hadn't demonstrated how that particular report would be able to be got into evidence in the criminal proceedings, and hadn't demonstrated why it would be in the interest of the administration of justice to give him leave to use it in the criminal proceedings.
So what did the full court do with the appeal from that decision?
Well, the full court upheld his appeal from that decision and allowed him to use it in the criminal proceedings. The reasons they gave for that were that something less than a probability that the report would be useful to the husband is required. The full court discussed ways in which parts of the report might be relevant in the husband's criminal proceedings, but they emphasised it wasn't up to the family court to get into the weeds of how that report might be used in the district court criminal proceedings. And they also commented that the information in the report might be used by the husband without the report actually being tendered. So for those reasons, they found that it was appropriate to give the husband leave to be able to use the report in any way he wished in his criminal proceedings.
And there was also an application by the husband to be relieved from his obligation under Section 114Q, which is the section that has replaced the old Section 121. How did the full court re-exercise their discretion?
Well, the full court responded to that application by saying that it was odious, it wasn't necessary, for two reasons. Firstly, the order allowing it to be used in the district court wasn't an order which was authorising publication to members of the public. It was to a court itself. And secondly, there's an exception as there was under the old Section 121 for anything that happens pursuant to a court order in relation to the publication of anything that's happening in proceedings.
We are now going to be talking about restraining lawyers from acting, information barriers, and intentional conflict shopping. Lawyers always seem to be interested in cases where lawyers are restrained from acting. What are the usual bases for granting an injunction restraining a lawyer from acting?
The usual bases are breach of confidence, breach of fiduciary duty, or protection of the appearance of justice. So they're the three main general categories under which you can successfully get an injunction against a lawyer from continuing to act for a client.
And there was a recent single instance decision of Mihova, which involved an application by the wife to restrain a firm from acting for the husband, but the husband successfully defeated it. How did he do it?
Primarily, the firm that he engaged successfully erected an information barrier around the lawyers who were doing the case for him in the firm to protect the information inside that firm. What had happened was that the wife had had a first conference with a lawyer of that firm and had then not engaged the firm.
So what did the husband's lawyers do in this case to effectively erect an information barrier?
Well, the trial judge described what they did at paragraph 27 of the judgment, and they did the following. The managing partner and the lawyer who saw the wife gave undertakings to prevent any possibility of confidential information being disclosed to lawyers now working on the husband's case inside the firm. The husband waived his right to receive any confidential information from his lawyers about the wife's first conference with the firm. The initial notes taken at that first conference were actually in writing and were not part of the electronic system of the firm and had been independently secured. No other lawyer had access to the notes apart from the one lawyer who had done that initial consultation. Undertakings were given that only 4 people in the firm were able to be involved in work on the husband's case, and the lawyer who did the initial consultation was instructed not to discuss anything in relation to the wife's first conference with any of the other practitioners in the firm.
So the judge was satisfied by these precautions and undertakings that were being made?
Yes, the judge found that the firm had effectively erected an information barrier, which meant that there was not going to be any risk of breach of confidence, and that was the primary issue in the case, whether or not there would be a breach of confidence as a result of the wife having a first interview with this firm.
And something that stood out to me in this case is that the wife went around to speak to multiple lawyers to conflict them out, and she did the same with barristers as well.
Yeah, she retained quite a number of barristers. The judge referenced that and took that into account under the third topic that I mentioned, that is the protection of the administration of justice, and she took it into account in the husband's favour.
How often do you think that tactic works in terms of conflicting out lawyers?
I think, unfortunately, it works quite a lot, probably because lawyers just think that once they've seen one side, they can't do anything with the other side. Secondly, if they know about erecting Chinese walls and information barriers, it's just a very big hassle. And so it's easier just to say to the new client coming in, sorry, we've already seen the other side in a first conference. That's why it works a lot.
Yeah.
It shouldn't, though.
Yeah. We will end today on the emerging issue of cryptocurrency and what you might need to do on an interim basis to preserve that asset. In the matter of Jingyi and Chao was a case heard by Justice Harper, which involved $2 million US in cryptocurrency. What was this asset, important in this case?
It was sort of everything in this case because it was the only asset that could be made the subject of a Section 79 order. So preserving it, so far as the wife was concerned, was paramount.
So what did the wife do to attempt to preserve the cryptocurrency?
Well, she approached the court for a suite of interim orders specifically targeted at the cryptocurrency. And in fact, Justice Harper made most of the orders that she sought. And those orders actually provide a very good precedent for this type of application for interim orders to freeze cryptocurrency and are making their way to our very popular order library. So those orders that Justice Harper made were firstly to appoint a trustee pursuant to Rule 5.15 of the FCFCOA rules to take charge of all the cryptocurrency held by the husband. He also restrained the husband from accessing any electronic devices or wallets that could be used for the purposes of dealing with the cryptocurrency. He required the husband to deliver to the trustee any cold wallet of cryptocurrency and required him to disclose to the trustee within 2.5 hours all IDs, passwords, private keys, recovery phrases and codes, two-factor authentication, and various other categories of information that would allow the trustee to access the cryptocurrency.
And what about the orders that were made restraining the husband from mobile phone use?
Well, the wife had applied for those orders that she have actually access to the husband's mobile phone. Harper J took a very conservative attitude to that application and refused to make an order that the husband give up his mobile phone to the wife for the purposes of a IT expert downloading the contents of his phone. And there's a phrase in the judgment which I'll just read out. Mobile phones are plainly devices which people conduct their ordinary lives by, and compelling a surrender of that phone, even for a short period of time, is potentially too onerous. Some other judges wouldn't have taken as cautious approach as Justice Harper did, but he didn't want to take the husband's mobile phone away from him. He thought the other orders that he made were sufficient to secure the cryptocurrency.
Yeah, I can understand that. And you mentioned, Gary, that we'll be curating these orders, a version of these orders, to go into our order library, which is available to our clients as well. And
soon, I think, to be put as a full stack app on our ribbon in Leap to make it even more convenient to be able to get to the orders.
Absolutely. Thank you, Gary, for this discussion today.
It's been my pleasure.
We've loved being in your ears for this bonus episode. Don't forget to like, subscribe, and share this episode. This is part 1 of a 2-part series, and we'll be back with Garry as my guest for part 2. We look forward to you joining us then.